have with us today the moderator of the panel discussion, Professor Juan Rodriguez, sir. Sir is 38th civil judge in the District of Cali, Colombia, and a professor at National University of Colombia. Sir specialized in constitutional law from the Javerian University of Colombia and holds a master's in fundamental rights and public freedom from the UCLM, Spain. Sir is also a PhD candidate at the Autonomous University of Madrid, Spain. Sir has published extensively in the field of constitutional law, international law of human rights, and environmental law, and in journals such as Constitutional Review of the Constitutional Court of Indonesia and other publications in countries such as South Korea, Brazil, Chile, and Colombia. A hearty welcome to you, sir. Now, I would like to request Professor Juan Rodriguez to please take over and to invite our respected panel members and kindly moderate the session. Over to you, sir.
Thank you very much, Professor Urbi. First of all, I'd like to express my thankfulness to the Hidayatullah University, National University of the India, to the organizing committee of this great conference, and of course, to my dear friend Uday Shankar, with whom we have made great collaborations in the matter of the protection of the environment here in Colombia, particularly in a publication called Climate Emergency. Today, we are gathered together to talk about the rights of nature for sustainable development in the context of the World Environment Day. And this, of course, sets up the importance of this panel. We are here with important panelists, Professor Adarsh Kumar Goel, who is former Justice of the Supreme Court of Justice and the National Green Tribunal. Thank you for these very enlightening words that you have given us in these moments. Also to our panelists, Gitanjali Njil, Paul Martin, and Elisa Scotti for their contributions that I'm looking forward to listen. I'd like to give a very brief introduction of this panel by bringing some light to the context and the state of the art of the law that we have currently in the protection of the environment, and making an emphasis on what is the role that the Indian judiciary has in this trend of public interest litigation that made possible this new trend of rights of nature. I'd like to say that as Chief Justice Kumal expressed, one of the problems that we have is that we tend to divide everything. And the first problem that we had in the protection of the environment is that when we set up as the international community the priorities of the fundamental rights, we divided these constitutional and international guarantees in the concept of the generations of rights. In this sense, we established in the international commitments that there were fundamental freedoms, such as the due process of law, that had to be immediately complied by the government in order to grant the efficacy of the Constitution. However, when it came to the social, economic, and cultural rights, but also to the environmental rights, they were postponed. They were framed only as promises that governments could fulfill eventually, but did not have to grant immediately. This problem of the division of the rights in generation, of course, made that these environmental promises were indefinitely delayed. However, the jurisprudence of the India in this trend of the public interest litigation, and is a common trend also in the global South, also framed as transformative constitutionalism, established that rights were completely interdependent. That you cannot conceive a right to life if you did not grant a right to health. That you could not grant a right to health if you did not provide the conditions to have a healthy environment. These precedents of the interdependence of rights emerged in the global South, but particularly in the India when it came with the trend of the public interest litigation. This direct enforceability of the social, economic, and environmental promises, of course, put the judge in the center of the discussion of the rights. In the sense that since the public authorities, governments, and legislative authorities were not taking serious these constitutional obligations, and given the fact that the Constitution gives actions and litigation tools to make it enforceable, people more and more start to come to the tribunals to ask for the protection of the environment in the connection, of course, as we said, with the health and the right to life. This is the case in the constitution in India, where Article 21 and Article 41, the right to life and the right to a healthy environment, are approached as interdependent rights. People coming to the tribunals, of course, change the whole perspective of how environment is protected. It moved from the focus of public policies to the focus of judicial review. And this is not only in the global south, but now more and more, even in the European Union, as it has been observed in the case of Urgenda in Holland, in the Netherlands. But what were the conditions needed for the judges to have an active role in the protection of the environment? First of all, there had to be a modification of the concept of standing. There had to be an extension of the possibilities of who can access the tribunals. The concept of standing would grant that not only you could represent your own interest in the litigations, but you could represent the interest of the community as a whole. This is why it's called the public interest litigation. You do not litigate anymore on behalf of yourself, but you can litigate on behalf of a greater interest. And I cannot imagine of any greater interest than that of the protection of the environment. And this modification of the concept of standing, of course, grants a principle of the law that is the universal access to justice. And this is why in this trend of public interest litigation, you can see even in the India Supreme Court cases and the National Green Tribunal cases that they would grant access even to foreigners into the court for the matters of the protection of the environment. In our hemisphere here in Colombia, but also in the United States in the Juliana case, this modification of the concept of standing to give greater access to justice implied that even the children, the kids, speaking on behalf of the future generations, could be granted a voice in front of the tribunals that were to decide on their current and future freedoms depending on this environmental sustainability. This modification of the concept of standing and universal access to justice, of course, gave this greater role to the judges in the guarantee of the environment. In this sense, the Supreme Court of India was innovative in setting up a new kind of judicial decision called the structural rulings. And a structural ruling implies that the court does not only solve the particular case, but establish orders for the establishments of public policies in the head of the government and the parliament. And also establishes that these decisions have to be followed up in their implementation by the courts that have made these rulings. In this sense, the structural rulings, as Justice Kumar Goel expressed, implied the follow-up and the monitoring of the environmental policies. And here, of course, in the case of the India, one of these very important structural rulings was the one in which the Supreme Court of Justice ordered the National Commission of India to study the creation of a specialized court on the protection of the environment, and this is the National Green Tribunal. This tribunal, of course, has no similar tribunal in a sense that is the first national broad influence tribunal that we have in the protection of the environment. But this example has been followed up by countries such as Chile, that now has an environmental tribunal, Ontario, Hawaii, and of course, the case of China, where they have also an environmental jurisdiction. This Green Tribunal, of course, implies that the judges in India have understand, and in this they are also an example for all of us, that there is a need to give voice to scientific opinions in the tribunals, because the environmental issues are not something exclusive of the law. They need to consult scientific reality in order to grant the efficacy of the contents and the promises of the Constitution. Now, landing into the topic of the rights of nature, I'd like to express that this new trend is only possible in the context of this public interest litigation, only possible in the sense that judges have been the one establishing the order to protect these environmental legal goods, and that in this sense, it has to be in the courts where you dogmatically construct these limits between nature and man. And in this sense, I'd like to invite the discussion of our colleagues of the panelists with the news that we have from Colombia just yesterday. As I said, this trend of justices establishing orders for the governments to follow up have been followed by other countries, and this is the case of Colombia. And this is why in my country, both the Constitutional Court and the Supreme Court have ruled these kind of decisions, these kind of structural rulings. They have, in this sense, granted rights to several ecosystems, such as the Amazon River and the Atrato River, and also the Otum ecosystem. One of these rulings established that the government should take care of Parque Nacional Los Nevados, and that Parque Nacional Los Nevados, or this National Park Los Nevados, is a subject of right, has rights of nature as a concept, and that in this sense, any public action exercised over this ecosystem should be consulted with the government, and the government should act on behalf of the ecosystems, giving them agency and entity in the tribunals. However, this order given by the Supreme Court of Justice to the executive power to protect the ecosystem was not followed with the complete standards set by the decision. And because of this, just yesterday, the Tribunal of Ibagué has issued an order of arrest to the president. So the president of Colombia today have been arrested or has an order of arrest by the Tribunal of Ibagué for not protecting the rights of nature of the National Park of Los Nevados. So this case of just very recently, as I said, puts us on practice what are the limits when it comes to the rights of nature. So to not take more time from our distinguished panelists, I'd like to, of course, invite them to tell us about the policies, how they are follow up in the European Union, how they define this concept of nature, whether something that is originally a thing can be turned into a subject, and whether these rights of nature are only conceived for the animals as beings that can have feelings, right, that can feel suffering, or to ecosystems such as rivers, mountains, and not things that cannot have feelings. So I'd like to again present our dear panelists. So would like to perhaps start with Professor Gitanjali and Jill, Dr. Gitanjali, so that she can give us the very interesting presentation she has for us. Thank you.
Thank you very much. Before I really start off, I'd like to thank the organizers, in particular Professor Vivekanand and Professor Uday Shankar, for inviting me to this international conference. The conference is context specific and geographically relevant because Chhattisgarh is a treasure house of nature, including biodiversity and natural resources. And that is why the question about rights of nature become very important. Before I start off, may I request Ankit to please share my slides? I'll be using my slides. Okay. Can it be?
I hope, is it visible, ma'am?
Yeah, it is visible. Will I be able to move it, or would you be able to move it?
I will do that.
Okay. So the topic of my presentation today is Rights of Nature, Place-Based Indigenous Knowledge. We are talking about one nature. We are talking about taking people together. And I think in this part, especially Chhattisgarh and areas which are very rich in nature and biodiversity, the place of indigenous people is very important. The way I have structured my presentation is just briefly introducing about sustainability from a place-based lens and the importance of indigenous and local knowledge, the questions or the complexities that are coming about in relation to the rights of nature and the rights of nature and indigenous people, particularly with the use of words like legal personhood and legal entity. Looking into the notions of reciprocity and governance institutions, and finally, some concluding remarks. Next. Yeah. When we talk about sustainability, sustainability is simply not green or environmental, though it might be one of the most important ingredients. But within the sustainability, the social and economic aspects play a very important role. And from a social aspect point of view, the place-based phenomena plays a huge important role because this is telling us about the understanding and the deep relationships that people and place have with one another. And this is very central where Hidayatullah University is situated, because India is considered as one of the nations which has a treasure house of biodiversity and natural resources. So understanding this people and place-based relationships is so important in order to achieve sustainability. And within this place-based, the nature of the indigenous people, their knowledge, their assets, their local resources plays a very important role. Knowledge per se is not only scientific, it has plural connotations, and the traditional knowledge and understanding and the relations which the traditional people have with nature plays a very important role. And if we are going to talk about sustainability, the beliefs, values, and relational experiences of indigenous people with nature must be reflected towards a move towards sustainability and sustainable development goals. Next. When we talk about indigenous and local knowledge, Burke's 2018 gives a very good definition of talking about a cumulative body of knowledge, adaptive practices, cultural transmissions that are taking place through generations, and its interrelationship with nature, with humans, and with one another. So we are not talking about knowledge which has just been acquired. We are talking about knowledge which is coming from generations, which is based upon experiences of the people. And that is so central when we talk in relation to sustainability. And that is why this knowledge has to be captured in order that we are able to develop effective governance systems. Because this knowledge ultimately contributes towards the benefit of the world, as these people know how to take care of the land, of the nature, and are very aware of their responsibilities in order to ensure that a balance is maintained between nature and human relations. Next. And it is here that I'd like to pick up a few words. Rights of nature have been very well established. There's a huge lot of discourse, and this recognition is also ingrained within indigenous and local knowledge. We look to any of the countries, Bolivia, Chile, Argentina, Ecuador, Colombia, India, you name it, Guatemala, you name it, and there is a recognition which is coming about that in order we have to have the rights of nature, the traditional indigenous knowledge needs to be respected. The traditional indigenous people have to be a part of in this process. But it is here that I find complexity arising, because this rights of nature discourse is being developed through the usage of 2 or 3 kind of terminologies. One is talking about legal personhood, and the other is talking about legal entity. The terminologies are very important for the semantic value, because it is these words which are going to tell us to what extent indigenous knowledge and experiences are manifested in the rights of the nature. Let me start off by saying about taking legal personhood. The Constitution of Ecuador in 2008 was the first constitution which gave rights of nature to the people. Nature, or Pachamama, has an integral right. Section 71 and 72 talk about people and communities play a very important role, and these are the natural persons and communities that are responsible in order to protect the ecosystem. So therefore, in order to have these rights, it's important that the indigenous people have to be involved in this process. Bangladesh in the year 2019, following Indian judgments, came up with a judgment saying River Turag is a legal personhood and has got the same rights, and therefore it should apply throughout Bangladesh. Next one. In India, again, the judgments are talking about legal personhood. One after the other, the judgments are coming. It started with the Uttarakhand judgments, 2 of the judgments which came about, which talked about the glaciers and the rivers, Gangotri, Yamuna, Ganges, rivers, streams, lakes, everyone getting the right. But this right was recognized as a part of a legal personhood. Similarly, in 2022, the Madras High Court has also talked about Mother Nature as being a living being and being given the legal personhood rights with corresponding rights, duties, and liabilities. 2020, Punjab and Haryana High Court also declared Sukhna Lake as a legal person for its survival. The Madhya Pradesh, the National River Ganga Act also provides for Ganges with legal personhood. Next one, please. No doubt these judgments are very impressive. Ankit, next one, please. No doubt these judgments are very impressive, but what do these judgments imply? Where do we define the rights of the nature and legal personhood, particularly in relation to the rights of the indigenous communities? What I feel is that this is a general term which has been evolved. Legal personhood is constructed according to the predetermined human-centric characteristics that travel together with the concept of a person, which we identify as natural person. And that is why we are all talking about human rights getting involved into it. But what this legal personhood also talks about is it can be invoked by anyone, everyone, wherever it is. GNHRE at the moment talked about standing, and that is where my question is really coming. For the purposes of implementation, fine. This is very good that you are giving this right to everyone. But then there are challenges that are associated with this question of standing. And these challenges are to be identified in relation to what the indigenous or the traditional people are facing. Essentially, this sort of a personhood which is being made, we know about personhood in law because we make everything as a personhood, like corporations. But this personhood has got no more moral, social, political, or historical character in its own. We have created this because it's convenient for us to create. The judges have done it, the legislations have done it, because this is a mathematical, as what Lawson says, it's a mathematical equation that has become for the purposes of simplifying legal calculations. But the question really comes about is, where does this indigenous knowledge fit into? When you're giving rights to each and every person, even a polluter, like an oil company or a mining company, can have this right. Where does then the rights of the indigenous people come about? Do they really have a standing to talk before these oil companies? And that's very debatable. Again, we have the possibilities of political element coming into picture. Do traditional communities have that sort of a power where they can make a representation in that regard? So when we are talking in relation to nature, and when we are integrating it with indigenous knowledge, this recognition that is being given is good enough. But in reality, when we say from a legal personhood point of view, there is a limited engagement which is manifested in the rights of these indigenous people. Let me go back to the Indian examples. Beautiful judgments which these judges give, which comes out. But look at the Uttarakhand, decision which came about. What did it say? The director Namami from Ganges, chief secretary of the state, and advocate general have been declared as the loco parentis of river Ganges and Yamuna. The justification of this judgment, these two judgments, was not given on the basis of the cultural aspects or the indigenous knowledge which the people had. But the justification of these judgments was basically given upon the Hindu notions of deities, which essentially was justified on the basis of faith and morality. So when you make these top-up people like Attorney General and the Chief Secretary sitting on those boards to look out for River Ganges and Yamuna or any other natural entity, where do these indigenous people have their place? They are the ones who are responsible because they have got the knowledge, the traditional knowledge, experience, relational ontology that gets reflected in the conservation and protection. So the point which I'm really trying to make here is that though there is a recognition of rights of nature and indigenous people, but the use of legal personhood, which we use in law as lawyers or as legislators or as judges, really has an impact whereby it limits the participation of the very people who are affected as a consequence of whatever happens in relation to rights of nature. Fortunately or unfortunately, I think one of the challenges, the more I do research on Indian cases, Indian environmental law, what I try to see is the loose usage of words that is coming across. Within the judgments, if you're going to open up all these judgments, you would find the use of words legal personhood, legal entity, juristic person. But then the meaning of these words has a meaning which has an impact on the lives of the people. And that is where it is now the moment for the policymakers, alongside the decision makers, alongside academics, to relook into these matters, to have a semantic value to the words that are being used. Because what we are talking about are the people, the marginalized, whose lives are getting affected. And once we recognize these people, it's important that we must take their rights to a logical end. Next slide, please. Next slide. As far as the next one is concerned, the second term which really comes about is rights of nature and legal entity. And I think this is the term which needs to be used, because if we have to give implementation, if we have to make sure that people, indigenous people, are involved in the process of protecting the rights of nature, we need to identify what legal entity entails. The question about the relationship between rights of nature and legal entity is essentially creating a space for the entity, which is a specific ecosystem, and the particular groups, which is the indigenous people per se. And that is where you are having the legal rights, which are subject to legal obligations. So what we see in legal entity, the concept of legal entity is, we are not only having the principle of recognition, but we are also having the principle of reciprocity. And as what Juan was talking about, there are a lot of cases that are coming from Colombia, Atrato River, there are rivers, lakes, Amazon rainforest. New Zealand is talking about Te Urevera National Parks as a legal entity. Northern Canada is talking about the conservation area, which is the Thaideen Nine Park and the conservation area. In all these situations, the courts, the legislators, whoever are the lawmakers, are using the term legal entity. And this is so important because we have to understand where the genesis is coming from, because it's all about the engagement of the indigenous people with the rights of nature. Next slide, please. And the reason why I say that is we already have a lot of recognition, but what we now need is the reciprocity. Because humans are in a reciprocal relationship with nature. And it is these human activities which basically are conditioned upon a responsibility in order to ensure that they stay within ecological limits. And despite anything, it is the indigenous people who have these values, experiences that reflect in this reciprocity. And this indigenous relationship mirrors and reinforces itself by treating nature as a relative and not as a resource. And that's where the questions about guardianship and trusteeship come into picture. From Colombia, we have the case where the court said that the Ministry of Environment, alongside 7 people from the communities, are regarded as the guardian of Atrato River. So what we are looking here, we are seeing that when you interpret the rights of nature with indigenous people, you are creating legal entities. And there is a distinct and a very pious relationship that emerges where the indigenous people become central in protecting the nature per se, because they are acting as guardians, they are acting as the trusteeships. Next slide, please. Similarly, in New Zealand, we have Te Awa Tupa, that's the Maori case, Wangani River, where they again have constructed institutions or mechanisms where the voice of the indigenous people is being reflected. Two nominated representatives are coming, though they don't use the word trusteeship, they use the word care and well-being. So by placing the traditional people, by placing the indigenous people and providing them with the voices, that makes a lot of difference whenever we are talking about rights of the nature. Similarly, to Urevara board, where we are talking about the forest area, 6 members from the indigenous communities are working alongside with the top-up people, including the ministries. Again, in northern Canada, we have an example where the traditional indigenous people work with the ministries in order to protect the rights of a protected and a conserved area. The point which I'm really here trying to make is that it's easy for us to talk about rights of nature, but the implementation, the real implementation of these rights of nature is dependent on the indigenous knowledge. And if we do not make these indigenous people as the trustees, as the guardians, it is not possible for us to take everyone into account. A top-up approach of ministers sitting or judges sitting or legislators sitting will never ever achieve the real implementation, because you're not giving an opportunity to these people to express. And what they are having is ethical and cultural knowledge, which scientific knowledge cannot provide. So we are talking here about knowledge pluralism. Knowledge comes from different sources. And that is why, if we have to make this as a reality, the involvement of traditional people as legal entities needs to be really taken into account. And it is here that the policy makers or the judges have to really start thinking about the semantic value of what they want. Do they want it as a legal personhood, or do they want it as a legal entity? Next slide, please. And that is, I'd say that for sustainability, we need transformative governance initiatives. And these initiatives are not only based upon recognition, but they are also based upon reciprocity. And what we are now seeing is different sorts of governance institutions wherein indigenous people are central in terms of protecting and conserving the nature. A Trato judgment comes up with biocultural initiative. It recognizes the rights of the ethnic communities, but simultaneously says that because there is a reciprocity, they have to be involved in the process of guardianship or trusteeship in order to ensure that the rights of the nature are being protected. We also have kin-centric initiative, and this is based upon an ecosystem approach where humans are considered as an extended ecological family that shares ancestry and origins. So what we are looking here is a relationship which is based on experiences, a relationship which is based on traditional knowledge, which enhances and preserves the ecosystem. And a very radical way, and some of the authors have talked about, is anthropomorphism. Rather than nature being centric, what they are talking about is detecting human personhood in non-humans. It is very ambitious because it starts about a relationship which encompasses both the intrinsic value as well as instrumental uses. So what they are saying is, rather than nature being centric, human beings become centric, or human beings are to be considered as a part of non-nature. Nature has got so many intrinsic values and its uses. It's very radical, but who knows? A radical judgment might bring about a change in that regard. In the end, last slide, I would like to conclude by saying it's a very timely international conference, but then if we want to have just and livable futures, rights of nature discourse are very important, but they have to have a semantic value. We need to understand because we are talking in relation to indigenous people. It's just not the recognition, but the reciprocity of their contribution through their relational experiences plays a very, very significant role. So understanding their value, appreciating, understanding, and applying their value and knowledge is needed to breathe life into a legal entity. And that will help in elevating the status of nature for all people and respect the laws of indigenous people. And this really feeds very well with sustainable development goals, because sustainability and sustainable development goals says no one should be left behind. So in this process, we have to recognize the importance of the indigenous people and start thinking about what terminology we need to use in order to make the rights of nature a concrete reality. Thank you very much. Thank you.
Thank you, Dr. Gitanjali, for your very relevant thoughts. Indeed, the central question or one of the central questions of this new category of the rights of nature is who effectively can exercise this guardianship of these ecosystems, whether has to be the international community or those indigenous people that have this ancestral knowledge and this ancestral relationship with the specific ecosystems that are being studied and protected by judicial decisions. Uh, Thank you, Doctor. Now I'd like to give word to Professor Paul Martin. Professor Paul Martin will also talk about legal rights, whether they are enough, and how can they protect nature interests in practice. Professor Paul Martin will point out some reflections of who will act for nature, or will nature only be a proxy for people, who will pay and how to protect nature, and what institutional arrangements are needed to make rights for nature meaningful. Professor Martin, thank you very much for your participation.
Thank you very much. I've been trying to connect my PowerPoint, but it doesn't seem as though that's going to work. So I'll just have to talk to what I have in my slides, and then I'm quite happy to share them later on. With such a fantastic panel and such experts who know so many things about the doctrines of different countries, I thought it would be foolish for me to pretend to any sufficient level of competence to engage with the doctrinal issues. And I thought to myself, what is the contribution that I can make that would be valuable, but which wouldn't just simply be going over ground that people have covered? And Professor Gill has just covered quite a lot of the material that I might otherwise have covered. So what I'm going to focus on is practical effect. And what can we do to take the innovation, which is rights of nature, and particular rights of rivers, and make it fully effective? Now, Justice Goal up front talked a lot about the problems that exist in India with rivers. I could talk just as strongly about what's happening in Australia, and we've done quite a lot of work with Brazil, a lot of comparative work on implementation. And we've got a study with 5 countries all looking at the implementation of international rules, principles. And the thing that these all show is that countries are fantastic at converting broad concepts into legal instruments. surprisingly good at that. They are less good at converting that into institutional arrangements to implement. They're far less good at actually doing the implementation, and overall pretty appalling at using the law to substantially change the relationship of man to the environment. And if we look at river rights of rivers, what we see is some quite radical innovation and people having high expectation that that innovation will lead to efficient change. Now, I would like to look at the innovation from an innovation theory perspective, not from a law perspective. And if you look at the way that computers evolve from large, slow mainframes to desktop to high-powered PCs to now, we've even got machine-generated algorithms where the software is not written by a person, it's written by a machine. The paradigm that starts with is very clumsy and it gets mature over time. Where we are at with rights of rivers and rights of nature is we're at the pre-paradigmatic stage, where it is great ideas, many different versions, very clumsy, and highly unlikely as it currently stands to do what people expect. So what I want to come to at the end of this presentation is something about what we need to do to make it more likely that we will rapidly evolve this legal principle into something that actually works. First point, many people think rights of nature are radical, but legal rights of non-human actors are not radical. They are reasonably well established and have been for some time. So I cannot point to a creature which is competition, but I can easily point to laws that protect the interests of competition. And so the step towards protecting rivers is not as great as a step towards protecting an abstract economic concept. There are four main sources of river right paradigms, and Professor Gill has just dealt with one of them. One is infusion from Aboriginal cosmologies. And there are multiple cosmologies, and so there are multiple norms from Indigenous people. I do worry a bit that we are expecting Aboriginal people or Indigenous people, First Nations people, to save us with their cosmologies. I think it might be asking too much of them and actually bypassing the responsibility of the rest of us. The second source is infusion from Western and other philosophies. So the philosophers arguing about the intrinsic rights of nature. The third one is constitutional infusion, where a constitution, for example, requires recognition of Indigenous norms or the interests of future generations or rights of nature. All of those can lead to a version of the rights of rivers. And the last one, and I suspect the most powerful driver in many countries, is it actually is driven by a political response about perceived failure of duties. And people grab a concept to try and resolve that. And I certainly think in the Australian situation particularly, any potential rights of rivers will come primarily from a recognition of the failure of existing law and a desperate desire to find what looks like a credible theory. And there we start going to Aboriginal cosmology and things like that. I'll come to that in a moment. So I've said we are in a pre-paradigmatic stage. There are multiple versions of rights of nature and rights of rivers. Implementation is very clumsy. There are some fantastic examples of it being done well, but mostly it's not being done well. And it is having relatively limited effect with a few fantastic examples that are different from that. So I asked myself, where to from here? So where do philosophy and rules meet with ecology and society? Well, laws are concerned with norms and processes, so with institutions, and social movements are concerned with culture, politics, and that. The environment, ecology, interacts with society through transactions. law does not have any effect until it directly gets into transactions by either changing the institutions or by changing the cultural activities. And so the question I ask myself, how or when or will rights of nature get to the point where it is reflected in the transactions that affect rivers? So if you look at, assume that part of the right of a river is a right to be healthy, then you would expect that it would, to get involved in transactions in a positive way, it would have to change things like how farmers work, how residents, townspeople work, how industry works, how we change the shape of landscapes, all of these things. Those transactions would need to be shaped by an obligation to control harm that mirrors the right of the river in some way. And if that doesn't happen, if we don't achieve system change at the day-to-day transaction level, then we'll end up with a vacuous concept of the right of the river. And that's not much different from human rights. There are plenty of human rights that exist that are not implemented because they don't get into the day-to-day transactions that affect human welfare. There's no reason why rights of nature would be any different unless we do something different. So when you look at that, you start to think of rivers in a system sense, going from rainfall, pure water coming down, water being stored, extracted, discharged. What you see is that there are many biophysical flows, there are many transactions, and there are many actors who make decisions. Farmers, industrialists, landowners, residents, politicians, and many others. And if we don't change their decisions, then we will get nowhere. So that means it's not enough to have good norms. It is just not enough. Unless you can change administration, policies, economics, and politics, then you will have a very slow path towards what we all want, which is more sustainable use of the water. So for rights of nature to work, you need good doctrine, that's progressing, and you need institutional entrenchment, and that's progressing far more clumsily and more slowly. So future river rights, what paradigms do I think will be needed? The first is that human rights, when they're effective, often trigger restoration and compensation. So something has to be given back. So in Australia, with the Mabo decision, which is a High Court decision, a radical decision, now almost 50% of our landscape is under Aboriginal ownership. That's a radical change, but it had to be a kind of a giving back, or rather recognition that Aboriginals still own that land. Similarly, for a rights paradigm to work, there also probably has to be violation for breach. It's a long way, we're a long way short of having a mechanism to trigger restoration, compensation, maybe some punishment, but to be fully effective, river rights need to do that. The second is that the link between rivers' rights and the duties of citizens to respect those rights has to be, that link has to be there. So we probably need to end up with a duty to respect the legal rights of nature. So the other side of that balance has to be in place. Third thing, there are so many different versions of what river rights are or what they might be, that probably we'll have to end up with a point where there is some form of synthesis or codification of the different forms of river rights paradigm, so that there is a clearer understanding in society of what this might mean. The next point, I think it's really important, you can't, mostly when people talk of river rights, they are actually not talking about rights of rivers. They're talking about rights of people to use a theory to pursue the interests that they care about. That might be environmental, but it might be an economic interest in a river. True rights of nature would require respective significance, someone who can simply act for nature. Sometimes this exists, but often it doesn't. Often we rely upon the individual citizen ultimately taking that action for the environment. And worse so, we often require an Indigenous citizen. And in most countries, the Indigenous citizens are those who are least likely to have the capacity to do what is needed. So we probably need to end up with strong representative litigants. We also need to have a developed learning about how to make river rights work. We're a long way from knowing how to make this work systematically, and that's something we need to do. And the last thing that has to happen for this to be effective, if we have to move from the narrative about doctrine and lots of wonderful dialogue, but we have to move to accountable norms, or rather societies and parts of society that are truly accountable for effective norms. We're a long way from that now. So I'll finish off with an Australian example. Australia does not have a right of nature or river rights. We do have a lot of nominal fragmented rights and duties that could approximate that. So we have environmental and water laws which place obligations on water users. We do have landholder duties in some jurisdictions. For example, in Victoria, there's a general landholder duty of care, and in many states there are duties of care about control of invasive species or other harm. And we have an existing, on paper, Aboriginal rights system that's expanding into water rights and cultural flows. So we have some components. For the last few years, we've had a very reactionary political system that has wound back a lot of the environmental protections. But we are now heading into a period where there are going to be some catalytic events. So in 2024, there will be a full review of the rules governing our main economic river system, the Murray-Darling. It's clear that our national environmental legislation is going to undergo reform, and it'll be genuine reform based on a pro-environmental government. Significant move in Aboriginal land and water rights are going to happen. And there is a document called the Uluru Statement from the Heart, which is an Indigenous statement of policies that's going to be given some effect. So things are going to move in our jurisdiction, but like every other jurisdiction, we have to get rapidly to the stage where we move from talking about the abstract theory in a fairly confused way to the point where we're talking about a coherent system for changing obligations in order to give real effect to rights. So I think I've done my 15 minutes and I think I will now stop.
Thank you very much, Professor Martin. I'd like to agree with you in the sense that rights of nature are not in itself something radical. You could only see the example of corporations, right? They are, as you say, uh, there has been a recognition of legal rights for non-human actors, also for this case of the corporations. And of course, you point out that between the obligations and the promises of the international instruments and the constitutions and the implementation of practice of these promises, there is a very big gap, and that we also have to question ourselves on who is about to bring a voice to these ecosystems, and whether we have an anthropocentric view of the ecosystem or an ecocentric view of themselves. Thank you very much, Professor Martin. I'd like to give now the stage to Professor Elisa Scotti, who will talk about the rights of nature from the focus of the European Union.
Thank you. Before starting, I'd like, if it's possible, to share my slides. I can't see the possibility on my screen.
Of course, Professor. Yes.
Thank you. Okay, thank you. Perfect. Okay, thank you. So let me start by, first of all, thanking all the organizers of this conference and the Hidayatullah National Law University, and in particular Professor Hidayatullah for inviting me to this really interesting discussion. My presentation is about right of nature in the European Union, and this is the case of a legal system that now is behind the great revolution that we are observing all over the world with the right of nature movement. In this revolution has less success in Europe, and it can sound weird because, as we know, Europe is under a green transition. We have a European Green Deal, and our target and commitment is climate neutrality by 2050, with a lot of different strategies in the environmental field, and they are summarized in the last environmental action plan that reaffirm the commitment of climate neutrality and puts many priority objectives, so climate neutrality, but also strengthening resilience and protecting biodiversity. And I don't want to list all the objectives, but the starting point is the strength of the choice of the European Union and the European member states. We know that the European Union has shared competencies on environmental matters with the member states. So the strategy is complex, and the minimum level of protection is designed at the EU level. The member states can only improve the level of environmental protection. So the starting point of the choice of the European Union is fundamental to understand the trend. But it is also important not only the specific objectives, but also the premise, because the last action plan is based on the recognition that human well-being and prosperity depends on the healthy ecosystem. And it is important from our point of view, so from shift the paradigm from the right to nature to the rights of nature. We highlight that this movement has less success in Europe. Let's try to understand the reasons. And we know that in our culture in Europe is human-centered for our tradition, for our humanistic culture, tradition, vision, for the Enlightenment, for rationalism, for the current nihilism, and also for our Christian roots. So we put at the center of our concern the human being. And another point that could in some way obstacle the acceptance and of the rights of nature strategy is the high level of environmental protection in the EU legislations. We will see later why. And also the sustainable development approach. I will come back later on this point. And also another point is the approach to environmental protection as a public interest, more than a right, a human rights. The environment is seen as a common, and human rights is something that came later in our mindset. Another point is the central role of NGOs in accessing judicial review under the Aarhus Convention, and it is something that could in some way create less emergency in the access to justice and the need of a popular action, actio popularis. So let's move on what is happening in Europe, because the trend is obviously changing in this moment, because we have a lot of scholars, politicians, and also cultural movement in favor of the recognition of rights of nature in Europe. And it is really important in this moment because we are under two different crises, the post-pandemic crisis, but also energy and economic crisis induced by the well-known international crisis, and it can put at risk our environmental target. And also we are under a digital transition that should be based on ecological principle. And so also with the environmental degradation, we can observe in this moment something that is moving in our mentality. One example, symbolic example, is the Pope Francis encyclical letter of 2015 that recognizes the intrinsic dignity of the world, and it is an important sign of changing in our culture. But we can see also a movement and changing in the European legal landscape. And we can mention a lot of different European rights of nature legal initiatives. We have a database of nature initiatives organized by two universities, Sant'Anna School of Advanced Studies, an Italian university, and the University of Amsterdam. We have also UN database, but focus on the European initiative. We have the database I mentioned first. And according with this research, we see around 50 initiatives with the different actors, political actors at different levels, at the EU level, at national states level, and at municipalities level, and so local levels. We have also NGOs, but also religious entities that are acting in favor of adopting this new vision. And also we have a variety of subjects of natural entities. So first of all, rights of animals, but also rights of nature in general and or right to specific natural areas. The same is happening all over the world with rivers, lakes, trees. And but let's try to see with more details some example. I will try to be brief. So we have a constitutional development. So linked to the green constitutionalism, legislation, litigation, petitions, and also programs of political parties in Europe. Yeah, we have to be aware that just a few of these initiatives in Europe are going to succeed. For example, we have an ongoing process at constitutional level in Finland, in France, in Germany, and also at the EU level, because we have the proposal for the adoption of a charter of the fundamental rights of nature at the same level of the European treaties. I will come back on this charter for its importance. Also in Italy, in Portugal and in Sweden, and we can mention in Italy that we can say that we had a half victory, because in last February we amended the Italian constitution, included in our first part, it means in the values the Republic protects the environment, biodiversity and ecosystem, also in the interest of future generations. And also the mention of rights of animal, but it is there is a mandate to state law to regulate the protection of animals. We can say that it is not the recognition of rights of nature, but is also an important approach, because is not the recognition of the human right to healthy environment. The environment, biodiversity, the ecosystem are protecting in the interest of future generations. So I think that is something that is an important step. Also in legislation, we can see some proposals. For example, proposal in Romania about a law for that to consider dolphins non-human person. And for example, the proposal in the EU to include ecocide in the Environmental Crime Directive. Unfortunately, as the proposal, the last proposal, does not mention, does not include the ecocide, but the debate is ongoing. And we have a lot of municipal initiatives, but for recognized rights of rivers, of lakes, but also in general rights of nature in local communities. But the point is if they are legally binding in some way. Let's see against this positive and normative backdrop what is happening in the field of litigations. So we have different cases that for the rights of nature. We can mention, for example, an action in Belgium that tried to affirm the legal standing of protected trees, but the court rejected the argument, and the same happened in Germany for legal standing for piglets. against law that allow castration without the application of anesthesia. And in both cases, the court highlighted that only human being has the capacity to hold rights and to have legal standing. And we need a specific provision for legal personhood, such as for legal person that have their personality granted by law, expressly by law. So there is this positive approach of European Court, and also the European Court of Justice, the Court of Justice of the European Union, as this is creating barrier to legal standing and to action for protecting nature. And the same approach, we can find the same approach in environmental law cases before the European Court of Human Rights. We have a lot in our the European Convention of Human Rights doesn't include the rights to the human right to a healthy environment, but the court is linking this right to the right of life and the right for private and family life. And so the European Court of Human Rights is deciding a lot of cases on environmental protection, so on city dumps, incineration plants, industrial installation. But the point is the strong link with the individual harm. We have a specific element, limitation, which is the so-called direct victim requirement. And so we need this link, and we can find some important step in the recognition of the legal standing of NGOs when the case is common to communities, and it is one way the court is trying to open his mind to the right of nature, trying to avoid this strong connection with the individual harms. The conclusion about legal standing also of the Aarhus Convention Compliance Committee is that is a widespread lack of access to justice across Europe, and it is one point for enforcement, for legal enforcement in the environmental matters. And looking at what legal scholars are doing, we have to, our starting point is that the prevailing view is the recognition of the importance and of the European environmental legislation, which is extensive, surely, and valuable. And so the common starting point is that there is no need to write new laws, to design new laws, but only to apply existing ones. It is the mainstream in Europe. So, for example, authoritative scholars said that it's important to try to promote access to justice before national courts, and that environmental law reflect in ecocentric perspective, and that the rights talk could distract from these ecocentric perspectives that yes, it's present in our, for example, biodiversity legislation or wildlife legislation. But is the idea that even if we have a strong building of environmental law, we need to strengthen it with the rights, with the recognition of rights of nature. We have two important studies of the European and economic at the European level. One is the 2020 study of the European Economic and Social Committee, entitled Towards an EU Charter for the Fundamental Rights of Nature. And it aims at underpinning the adoption of this charter at the European constitutional level. Okay, there is a second option to adopt an interinstitutional non-legislative act, and it could be a second best, easier to be reached, but not non-binding. And so, but the importance of the Charter of Fundamental Rights is to adopt a new vision, new paradigm. So to abandon the current sustainability model and adopting a rights of nature model, which is different because we, in the second, with the new vision, we recognize that we are inside the planetary boundaries, inside the nature boundaries. And inside the green circle, we have to put our social and economic and our economy. And so it means that they are recognizing that we surely need to implement the European legislation, but it is not enough. We have to switch our paradigm. We have to redesign law and to have to adopt a new view. First of all, it means overcoming fragmentation, so the sectoral view, and to adopt a more integrated policy. And it means also to abandon and to adopt ecocentric view, and it is not only an ideological point of view, but it means principle of eco-law. So the proposal of this study is really clear, introducing substantive rights of nature, identifying new rules and methods of interpretation, of designing and interpretation and application of the law, especially within the discretionary power of public administration and states. And also the obligation, it means the obligation to take into consideration the right of nature in all EU policies, not only before courts. And also we have specific rules, so they are asking to include in the European principle of environmental law the rule of non-regression, the rule of resilience, the rule of indubio pro natura et clima, the rule of sustainable democratic method, so inclusion, and the rule of responsibilities toward nature, with, and it is important from a legal point of view, with the reversal of the burden of proof. Okay, and after this study with these important findings and proposals, we have a second study in the EU, a study committed by the EU Parliament that is based on a skeptical point of view. First of all, the question is right of nature is really a shift of paradigm, and the solution is to minimize the role of this new movement and vision, and as a new label in the system, so only a formal and ideological change. And the point of this, the idea of this study is that the main problem is enforcement, and one consequence of this approach is the last proposal that I mentioned before, of the revision of the Environmental Crime Directive. The first idea was to include the crime of ecocide, but lastly and surprisingly, the last proposal does not recognize the crime of ecocide. And but these studies full of also of pragmatism, and so the starting point, I said, is the need to enforce European environmental legislation. So it admits that from this movement, an important finding is the recognition of legal personhood. That means for us to strengthen the legal standing of NGOs, and to introduce legal standing for each individual's actio popularis, popular action, and it surely can strengthen the enforcement of European environmental legislation. And another important, interesting, and I conclude with this, an important recognition from this skeptical point of view is the recognition of the importance of the principle of non-regression. And it is, I think, an important point, because in this moment, as I said, we are facing two important crises: the post-pandemic crisis and the energy crisis in Europe. And we are also facing a digital transition, and all of these situations can put at risk our environmental goal, but also our environmental achievements. So the non-regression principle, I think that in this moment is really important. It's important to improve our steps, but also it is really important avoid weakening our environmental laws. So I think that I took too much time, so I thank you again for let me joining this conversation, and thank you.
Thank you very much, Professor Scotti, for this very relevant insight you bring us from the European Union law. Indeed, the starting point from Europe is the Judeo-Christian tradition and an ethnocentric vision of the law. And from this point of view, of course, the contribution is radically different. You have this goal of climate neutrality by the 2050. And I would say that now to this challenge is added that is also a matter of national security, of European Union security to achieve these clean energy goals, given the situation of the war. And also, in this sense, becomes more relevant the typification of this crime of ecocide and whether this is an interest that could be also even framed as an international crime, as some of the scholars have proposed. Thank you very much, Professor Scotti. Now we need to do the concluding remarks of such complete and genius presentations by my colleagues here. However, I like to stress out some common points that were talked about by all of them, which is also the center of this discussion, which is the concept of standing. The concept of standing from a procedural perspective means who is able to act in front of the courts and advocate for rights, but in the context of the rights of nature means who talks on behalf of the ecosystems. We all come from a common starting point of view, which is that nature cannot talk by itself. It needs someone to do it. It needs someone to act in front of the courts. And this is, of course, the problematic issue, because we cannot decide unilaterally who has a greater interest over the ecosystem. So we have, of course, the presentation of Dr. Gitanjali. She talks about the rights of indigenous to represent the ecosystem, but also we hear that from the European Union, Professor Scotti points out that NGOs have this right to advocate for the environment. So this is a great question, of course. Also, the other question that was pointed out and successfully answered in this conference, and that is the premise of the question of the standing, is the vision of the law that each nation has. This is a global problem, but of course, as we have seen, each country approaches this issue differently. First, we have the European tradition, as Professor Scotti pointed out, comes from a Judeo-Christian point of the law, which is essentially ethnocentric, homocentric. Why? Because in the Old Testament, in the Judeo-Christian tradition, the man is made in the image of the God and is placed above the other beings of the nature, animals and ecosystems. While in the rest of the world, the situation is not necessarily the same. Of course, India, I would understand, that has a much more comprehensive approach to the environment, more equal. The Indian law tradition sees the environment as part of the humanity and not the humanity as above the environment. And in this, if we are going to point out to a solution, we have to be respectful of each point of view of each of these nations. And in this matter, I like to quote Onuma Yasuaki, who talks about the civilizational spheres, that there is a Islamic point of view of the law, there's also a Christian point of view of the law, there's an Eastern point of view of the law, and that each of these local views have to be consulted in order to define something universal, such as this goal that the international community has fixed, which is fixing a crime of ecocide and fixing the environment as a global legal good. So we come back to the question of the guardianship. Who can exercise the guardianship of these ecosystems if we recognize that they cannot talk by themselves? This is also relevant to achieve the problem that Professor Martin pointed out very successfully, which is that these promises established in international law and constitutional have very poor efficacy. So we have institutional proposals, institutional mechanism, but they are very non-efficient when it comes to reaching the environmental goals. So we have to come back again to define who will exercise this representation, whether it would be the indigenous or if we can consider the environment as a global legal good whom we all can relate, and we all have this responsibility to protect. I think that from this starting point and this dialogue between jurisdiction, we can construct a public policy, hopefully an international public policy. We need more international agreements, but we need this jurisprudential dialogue that it comes with the work of the academics, such as yourself, that have made the effort to study comparative law, comparative experiences. And I think that in this sense, this conference and the fact that it has been organized from the India is particularly important because India has been a leader in the judicial protection of the environment. And as we can see, there is the growing interest from Australia, from the European Union, and even from Colombia in their presidents. And in this sense, I would just thank and invite our colleagues to continue to contribute in this very interesting debate. And as a proposal made that we can make as high as last remark of this conference, stress what Judge Kumar Goel pointed out, that we all have the duty to guarantee the conditions of living of ourselves, but particularly of the future generations. In this sense, the future generations could be the inspiration that we have for this work. Because when we talk about who can exercise the guardianship of the ecosystems, we have to think not who does it, but for whom you do it, right? So the indigenous people and advocates, they exercise the guardianship of the ecosystems, but they don't do it for the ecosystem as itself, because the ecosystem doesn't talk, doesn't feel, but they do it for the future generations that are entitled by the constitutional promises to enjoy these ecosystems that we currently enjoy, but we don't have the right to dispose for others. Being said that, I'd like to thank again to all of you for this very successful event, and I give again the word to Professor Urbi. Thank you very much.
I am also very much thankful to Professor John, who has very rightly and critically has proposed the concluding remark. He is Professor, National University of Colombia and 30th Civil Judge of the District Cali, Colombia. So he has very nicely concluded today's panel discussion. And actually we have started our conference firstly with panel discussion, and then we have kept purposefully the 4 technical sessions, in that so many papers will be presented throughout the India, and some participants, some paper presenters are from abroad as well.